Hello, everyone. Welcome to the Office of Technology Commercialization July webinar. We have Matt Upton with us, the Senior Associate Director for Intellectual Property Development, and he is going to be walking everyone through our new electronic innovation disclosure form. Matt, I hand it over to you.
Thanks, Jackie. Well, I'm excited because we've been working on this internally for a while with our vendor for our database. And hopefully we have something that will make this process easier on both our innovators here at UK and also internally as well. Excuse me. The first question is, how do you access this, right? How do you get to this online portal to disclose online? And that is very simple. So essentially, you can go to the UK OTC website and go under UK Innovators, hit the drop down, and we have two links, one submit an invention over here, and then the submit an innovation over here. And we've also added a FAQ section to answer some of the typical questions. In addition, if you experience any issues with it, it has links on who to contact about whatever error you're experiencing. It may be a little bit of a growing pain. One thing we have found already is if you get an error message, try a different browser. Firefox seemed to have a little bit of an issue, but Google Chrome did not. So you may want to use a different web browser when going in, but we know that Google Chrome does work. And then essentially all you have to do is follow the link out, and then it can take you there. The reason it can't be found is for the simple fact that I'm already a user here. So, but I want to show you on the test site. So what you will be presented with is a login screen that kind of looks like this. And you have a username and password, but don't use that. Use this down here because we have it linked. Our vendor is linked with all of the Link Blue accounts that we have at UK. So if you go down here and log in using your Link Blue, you would typically be taken to a screen where you just put in your Link Blue email address and the associated password, and it'll take you to it. Mine is automatically saved, it's cached in, but when I say Link Blue, I mean the email address that is the 3 to 4 letters plus numbers at uky.edu email address. And then from there, you'll be presented with a box over on the right, and then just select innovation. And this is the online submission form. Now, anyone that submitted an invention before realizes that the old form was 9 pages, a little bulky. This, when it's all together, is roughly about 2 pages. However, we did split it into sections, and the reason for that, and you'll notice the sections up here, is it allows this to be saved as you're working through it. So with that, it means you don't have to sit down and complete it all at once. So you can start a section of it, complete that, come back, and pick up where you left off. So that'll make it a little bit easier. So in going through this, I just wanted to walk through it and let you see some of the stuff and kind of explain why it's there and why it's needed. All right, so first off is title. So whatever your innovation is, whether it's a nursing intervention, a new drug, whatever it may be, we need a short title. And the reason that's important is we can't put it into our system without a title. And the person to best define what that title is, at least coming to our office, are the innovators themselves. So anything that you put in would suffice. Then the next part of this is the lead inventor details. And what we mean by lead inventor is the inventor that our office will communicate with, right? So there may be points in time where, we send out emails. We typically try to send out emails to every innovator on in one of our disclosures. But this would be the person that is in charge of like communicating to our office for the innovator team. It's not, PIs, it can be, but it's mainly for that communication of our office to know who to contact if there's a question and we have to have an answer on an issue. So under there, it's just you need your full name. So now that everyone knows my home address, you can come over, we'll play board games. And then percentage of innovation contribution. So this is something that was always done in a separate form, and we wanted to bring it over to the disclosure side, so we have it right from the beginning. So essentially what this is asking is for each inventor that you put in, so in this case, myself, how much of this invention have I, contributed to? So whoever is filling this out can put in whatever it is. So next is two questions. One, is this innovator a UK employee or a UK student? If they are a UK employee, select yes. And then we have this new line in here, employee ID. So this is not the link blue. This is, as it says, employee ID. And the reason this is important is because the university has gone through that initiative of scholars here at UK that makes all of our researchers work, whether that is, articles they've written, scholarly works in journals, whatever it may be, is being put up on that scholar's website. And this is going to be linked into that. And the way that it mines data is through an individual's employee ID. So that is linked all together. So that scholar system will ping our database using that employee ID number to pull up any disclosures, patent information, and use it to populate on that scholar's webpage. Link blue ID also needs to be put in. Again, that's that 3 to 4 letter followed by 3 numbers at uky.edu. And the reason that is important is that provides a login for all of the users to see the status of their innovation along the process. And we're currently working to try to update that and make it a little bit more transparent for all of our innovators. There were some features we previously have not used in our database known as Sophia that we are attempting to integrate those in, and it would give our innovators a better tool to find out exactly where in the patenting process their innovation is. And then next is college and centers. So we do have a drop down, so you can select the college that you are in and the center, excuse me. And then we also have department that you can write in as well. The reason that is important is that under our administrative regulations, anytime innovation is commercialized, the income received after all expenses are paid out according to a formula. And that formula is 40% to the innovators and then 60% to the university, but that is split up between 20% to UKRF, 20% to the college, and 20% to the department. So we need to know where to send those royalty payments if we do get a license agreement on that innovation. Next, just the university address. So where are the offices of the individuals or the space that they're working in here at the university. In addition, we would also need the position that they are, associate professor, a grad student, whatever it may be, a telephone number, email address, and a home address. And the reason the home address is important is that's the information we need to actually file a patent or a copyright, whatever it may be. We actually need that home address of the individual, not just an address at the university. In addition, and probably more importantly, is that if the innovation is ever licensed and royalty payments are due to the innovators, we have to have a home address. We cannot issue a payment to a university address for royalty. So we need a home address. And then once that is, and this is all essentially other than the employee ID, all information that we requested previously. If it is not a UK employee, and it's a UK student, it's essentially the same information. It just, that gives us a way to track in our system of who are students, who are employees. And if you have additional innovators, which most of these do, you can simply click the radial yes, and you're given another line, and it's essentially to fill out just the same as the first. Now, we can only accommodate up to 7 innovators. It's very rare that we have an innovation that comes in that has more than 7 contributors to it, but it can happen. If you need to go beyond that limit of 7, you can always just add one and attach it here. And then we'll get it and can add them in. But we wanted to make it easy to fill in and save. And 7, like I said, was the limit we could get from our vendor. Next is a complete and accurate description of the innovation. And this again was on our old form. And we just need a description. Now, if you are working on a manuscript or things like that, you don't have to populate this box. You can literally say, see attachment, right? And if I could spell this morning, see attachment, and then down here, attach whatever you want. Now, I'm just going to fill in some things here. And yes, you can cheat the system. Please don't cheat the system or we'll have to return it to you. But I need to be able to go on to the next page because all of these, if you'll notice, are required. So after you fill out the innovator section on this, then you're presented with a series of just simple questions. Some of these have to be completed, others do not. The ones that are required are indicated with the red asterisk. So we're hoping that this, for those that it applies to, will make it easier. For those it doesn't apply to, it won't be as daunting to see 4 or 5 pages of empty boxes that you believe you're expected to fill out. But very important in all of these is, was the innovation conceived or first reduced to practice and performance of work funded in whole or in part by federal grants, contracts, or subcontracts? So a lot of our work here at UK is funded by NIH grants, other federal grants, USDA, whatever it may be. And if the answer to that is yes, then we pull up the information that we need, which is the sponsor, the grant or contract number, who the PI is, the sponsor's department or center, if there is one. If there isn't one, you can just put NA in there, and then the award date. And the reason why this is important is once you submit a disclosure that is funded by one of these federal grants, our office takes over the compliance for that. So there is a system out there that our database talks to. It's called iEdison. So once you submit something with federal funding, we have an individual in our office, Sabrina Darnell, that works on the iEdison reporting to make sure we are compliant, to make sure the university can continue to get grants and that you get your next tranche of money under the grants. And we need this information to accomplish that. Now, this would be for one grant. If you need more grants, we also have the ability to add in additional federal funding and just repeat it for however many grants you have. The most I've seen so far is, I believe, 5 federal grants on one project, and we have the ability to add those in. Chiefly among this is make sure we have the sponsor, make sure we have the contract number, and make sure we have the award date, because that's the critical information we need to communicate to iEdison. All right, but if you don't have federal grants, you can literally just select no, or none in each of these. Then in addition, were any of those grants or subcontracts awarded to an entity other than the University of Kentucky? So sometimes we collaborate with other researchers at other institutions, and we would need to know if that is done under a federal grant, and just what institution that it was. Was it developed in a non-UK facility, right? If that doesn't apply to you, just none or no. Were the awards or support provided by any other source? If they weren't, then you don't have to worry about it. If they were, then you can go in and who was that sponsor, right? We get some sponsors that aren't federally funded, but still have reporting requirements. American Cancer Society is one that comes to mind. There are a couple of other nonprofits out there that provide research funding, and they have reporting that we have to maintain. And we need that information just with the federal to report to them on the activities or any intellectual property that has been filed related to that grant or award. And essentially it's the same thing. It's the sponsor, the source of the award number, who the PI is, and then the date that it was funded. All right, and then we get into kind of the disclosures, more of the nuts and bolts of the IP side of things. And essentially is, we're asking, has this been disclosed previously? If it hasn't, then just none. If it has, only then will you see, what's the name of the publication and the date of publication, which is very important to determine any bar dates that may prevent us from filing a patent or setting a date when we know we have to get something to the patent office by to avoid losing patent rights. And then, have you submitted something or has it been accepted? If that's no, you can just click none or no. If yes, again, name of publication and then the estimated date of the publication. Has it ever been sold? Which is typically not the case. I've never actually seen a disclosure come through that had a first sale. So typically just none, but if you do, you can provide the dates in which that occurred. And then were any materials, biological or otherwise, documents, information, software that was provided or disclosed by a third party used in the development of that? Typically that's no, but if yes, then we ask, is there a confidentiality agreement in place? If there wasn't, then you would just select no. If yes, then let us know. Because the only thing we want to know here is if that has occurred. Because if it has, we need to make sure we're in compliance because we're using someone else's goods. And then, are there plans to discuss this innovation within the next 3 months? Meaning, are there plans to talk with the company? Is there plans to go to a conference, whatever it may be, not just publishing, not just a manuscript and a journal article, but are you going to go to a conference and give a presentation? Are you having a company in to take a look at this? And if so, we'd like to know what that is to make sure we can get the right either protection in place by filing a patent application quickly, or to get an NDA in place if it's a business coming in to talk about the research or innovation that you have. So anything, and I did this because I knew that this one was selected. So there's some of them are required. There's only one on this page essentially. So you just can't leave it as none. Just go back, select no, and then hit next, and it takes you to the next page. All right. And here's some other questions. A lot of our researchers have dual appointments, meaning they're both part of the VA and part of the University of Kentucky. If that applies to you, then click yes. If it doesn't, click no. And then, is the innovation related to a third-party agreement not already identified? So if you received a material under an MTA, did research and develop some innovation based on that, we need to know that. So that way we can inform the other party to the MTA, So if that is the case, then select yes, and then we know to ask those questions to get with you to find out. If not, again, just select no. And then the same thing was equipment used from a third party under an agreement. Is the innovation result of a sponsored research agreement? Why that's important is that our research is, when it's under a sponsored research agreement, there's already a built-in license to the sponsor of that research on a non-exclusive basis. But that means we also need to contact them within 45 to 90 days, typically, depending on the contract, to give an opportunity to that sponsor for a exclusive license. And that's written into the contract. So we need to know if it was done, if the innovation was a result of that sponsored research agreement, so we can reach out to that sponsor and fulfill the duties of the contract that was signed. Next was the innovation developed using KCF funding. Again, if it was yes, not no. Were there any other types of agreements covering these, such as consulting agreements? A lot of times our researchers enter into consulting agreements outside of the UK ecosystem. And if that's the case, we need to know, to be made aware that there could be other contractual obligations under that consulting agreement that we have to deal with and be aware of. Next is other contributors. Did any person other than those named as inventor above contribute any of the following to the innovation? So software, other forms of copyright material. And then if so, we require a list. Since I've been here, which is coming up on 3 years, I've never seen us have to check this, but if we do, you just have to let us know what it was. Was it software, data for a database, or a data or a database, any text, audio recordings, or other copyrightable works? So essentially, if you go out and your innovation is a intervention, but you're using a copyright from someone else to form a portion of it, we would need to know that, because just because you make alterations or changes, we may still have to get permission from that original copyright holder. So if you're using anything along those lines, any software, data, text, audio, video recordings, we need to know, just to be able to contact them and make sure we can do what you want to do. And then the same thing with biological materials. So were you using the biological materials of someone else? And is there any limitations on what we can do with those? And again, this one, if it's yes, it's literally just a yes, so we know to ask you that question. Right, so almost completed. So essentially, this is just the conception date and the date of first experiment demonstrating the innovation. And the next section is this related to any other prior invention reported to OTC? And if it's yes, then we would just, every one of our inventions gets us, well, innovations gets assigned a 4-digit number. Well, we're 4 digits now, eventually it'll be another digit, but we're in the 2700s currently. And all of the emails that we send out related to that typically have those numbers in it, or the patent number, or application numbers, whatever it may be. But if your new innovation is related to a previous disclosure, this is where we want to know about it. And the reason that's important is because our database is what's a relationship database. So we can link things up and make sure that any commercialization individual working on those innovations will know that, you know, maybe this is a package deal. Not only do we have one technology, we may have an additional technology, and that's good for them to know, because it's always more valuable if you have a package of IP versus a singular patent. So companies are always more interested in a suite of technology rather than a singular technology. And then the next is just applying to, you know, your information about the field, because, you know, our innovators that turn this stuff in, we're not the experts, you guys are the experts. we know about the commercialization side, but our researchers know about the technology that's out there. So in the first box here, it's just essentially what's the closest relevant technology that you're currently aware of, and how is your technology different, right? That's the important thing that any potential licensee is going to want to know. Why should I go with your technology versus what's currently out there? And this kind of gives us a head start to figure out, what avenues we can go down from a commercial standpoint, because we can say we are different than that technology because X, Y, and Z. Now, some researchers may know this information, others may not. If you don't, just put NA in there. If you do, though, it would be greatly appreciated and it greatly helps the commercialization of the technology. All right, so the last is essentially just some additional questions. You'll notice that one is fed over from the previous page. And then one of them is, will research on this innovation continue at the University of Kentucky? Yes or no? Because sometimes we get some submissions and they're a student and they're leaving, or it's a researcher that's going to another institution or out into industry. So we'd like to know, at this early stage that you have submitted this, will work continue to be done here at UK? Because a lot of times our inventions still need some work before industry becomes interested in that technology, because they want de-risking to be done, or maybe there's a benchmark it needs to hit before they become really interested. But essentially all these questions are related to the commercialization side of things. So, the first one, what critical commercial problem does this innovation solve? So what is your technology solving? What is your innovation doing that hasn't been done before? And then again, the one from the previous page, how are you different than existing technologies? And then possible commercial applications would include, we get in a lot of filtering, but can it be used for just water filtering? Can it be used for other types of filtration? That's things we need to know on how to market that technology. And if you know of any company that's out there that is in this field that may be interested, or that you have talked to at conferences and things like that, we would love to hear, if you know of any company, so we already have a head start on who to contact and start reaching out to. And then the last page is essentially just the same thing that this is the same kind of language we had on our PDF disclosure forms, but it's essentially the University of Kentucky requires all potential innovators who are its faculty, employees, or students to sign this innovation. Once we review the innovation, we will send a document for each UK inventor to sign. This is a required step. Please acknowledge you understand that each inventor will be required to sign prior to any action being taken on the innovation by checking this box. And you can check the box, hit next. And then the last step is literally just a submit. So you can review all of the information here. Scroll up and down, see what your title is, and then hit submit, and it will send it over to our office. And the process there hasn't changed. It'll go in to our system. We'll still have to enter some of the information manually. Let me stop sharing if I can. There. And we'll still enter it. You'll still get the number. We're trying to work with some automated emails, but this database and UK's email systems do not play nice when we're looking at automated email systems. But we're moving to this online disclosure because, one, we think it'll be easier. It's not as intimidating as 9 or however many pages the original PDF was. There were always issues with the PDF. If people hadn't updated Adobe in a while, it was causing problems. And this should eliminate all of that and give you the ability to save filling it out so you don't have to feel that you have to commit a huge block of time to fill out the entire thing. And generally, get the information we need so we don't have to hound you about it, right? So, there is some additional information that we need, such as employee IDs, but all of that has been, that is needed to make sure that the scholars pages work and that database can talk to our database. So with that, if anyone has any questions, I would be more than happy to answer them.
Thank you, Matt. As Matt said, if you have questions, please put those in the chat and we'll ask those. Matt, can you talk a little bit about how much information a person should include in their innovation disclosure form on the actual ideal or innovation they have?
As much as you have, right? We have the ability, as you saw when you're having to describe your innovation, to attach files, right? So if you have data, if you have draft manuscripts, things like that, absolutely feel free to attach as much as that as you want, because the more information we have, the better search we can do, and the better, just at the end of the day, the better patent application or copyright that we can get, right? So the more information, the better.
Thank you. If someone is just wanting a copyright or trademark, do they need to fill out this form?
Yeah, so regardless of what type of intellectual property we're talking about, whether that's patents, copyrights, trade secrets, trademarks, whatever it is, you can use this to fill it out, right? Because the description is, kind of, if it's a copyright setting, it's, a book, or a computer program that does this, or a web page that does this, right? But the same kind of rules apply for copyrights as they do for patents, in the sense of, if you had federal funding, we still have to report those. We still have to handle all the compliance needs. So we still need all of that information. And that's why we kind of changed some of the language too, and went to innovators instead of invention, and disclose the innovation, because there was some confusion that, well, I don't have a patent and this thing says inventors, and inventors apply to patents. So we wanted to make it more inclusive to say, look, if you've developed some type of intellectual property, whether that's patents, copyrights, trademarks, trade secrets, we still need to know about it, because, like I said, there's still a lot of compliance issues that we have to do for all types of intellectual property.
Can you talk about when someone should actually submit a disclosure form to OTC?
Well, the earlier the better. So, so not so much when you're starting research, but it's essentially when you move from an idea to an embodiment, right? So intellectual property in and of itself never protects an idea. It protects the embodiment of that idea. So once you're to a point where either you have or have the ability to explain to someone how to build an embodiment of your idea, then that's the point in which I would encourage you to submit a disclosure, right? So if it is, in the pharma space, whenever you have some molecules that you've done some initial testing on, that's the time. In, the engineering space, whenever you have drawings of something that you think is workable, that's the time. If you're in the social innovation arena, whenever you have, essentially drafted an intervention to something, that's the time, right? You don't have to wait for proof of concept. You don't have to get the validation on it. That will come, and that may impact when we file IP and what type of IP we file. But essentially, the sooner our office knows about the innovation, the more help we can be, actually.
Someone need to have a working prototype to submit an invention disclosure?
No, and this kind of ties into the last one. So there's no need for a prototype. Like I said, it is when you get to that point where you go from idea to being able to explain to someone an embodiment of that idea, that's what you need. That's the requirement from the patent office or, you know, the copyright office or whatever it is. Once that idea has been either put down on paper in the sense of a copyright or in terms of a patent, once you can explain to someone else how to do what you want to do, then that is sufficient to start obtaining IP protection. You don't actually have to build, you know, the thing or have a prototype. Sometimes it's necessary for, you know, if you still have some, you know, there's multiple options you can do and you're trying to do a proof of concept, you may build a prototype just to find out which way functions better. But it's not necessary from the patent office's point of view.
If an innovator is collaborating with someone from another university and that person's planning on submitting a disclosure to their university, does the faculty innovator need to disclose here as well?
Yes, and I would encourage you that if you're in a collaboration, that all parties involved, whatever institution they're at, need to contact their tech transfer offices. And the reason for that is all the parties have a duty for compliance, right? In addition, we also enter into these agreements called interinstitutional agreements. And it is very hard to do that if there are tech transfer offices that are unaware that there has been an invention, right? So if you have collaborators, absolutely submit it to our office. And I would encourage you to also tell your collaborators to make sure they submit it to their tech transfer offices as well.
Like we have one last question, Matt. Should I disclose my innovation using the same writing style format that is found in a patent?
No, we just want to know what the technology is, right? You don't have to write, you know, you don't have to go out and research on what a patent is drafted like. We would prefer just the science, right? And the reason is there's kind of this strange art form to drafting a patent, that you want to be inclusive of what the invention is, while still being vague enough to be broad, but enabling to you know, what the invention is. So there's a lot of requirements when drafting a patent, and that's why patents read strangely. So whatever you have, if you have a manuscript, if you have just a write-up, whatever it may be, or just data, you know, you have the ability to attach that, and we work with really good outside counsel that can take that and then, you know, use their experience as a patent attorney and putting in essentially, you know, patentees to file the patent applications.
Thank you so much, Matt. I appreciate you walking through our new innovation disclosure. We're glad to see that finally as an electronic form and hope that will be much more beneficial for our innovators. Would like to tell everyone that we will have another OTC webinar on August the 11th at noon, where you can meet the contracts team and hear about how we handle non-disclosure agreements, confidentiality agreements, data use agreements, and why you need to contact our office when you're working with any type of that information. Look for that on our website coming soon, registration, and we will send this recording out to everyone and also post on our YouTube channel. And we look forward to seeing you next month. Thank you.